we're going to go right into our questions now. So the first question is, what if your HOA does not want to levy monetary fines? So I don't know if you're on your board or if you are a homeowner and maybe you're upset about a neighbor, but really it's up to your association's board. It's their choice as to how they want to handle violations. So, what I can tell you from experience is it's a great remedy. As long as you follow the law and set it up correctly, it's a great remedy to get owners to bring their lot into compliance. If the HOA chooses not to do it, it's basically the board's decision. Get on the board, think about running for the board yourself, ask your board, why aren't you doing it? Maybe show them this presentation so that they can see the benefits of using fines to get compliance. Okay, the second question is, requiring homeowners to park in their garages enforceable if the ruling is in the CC&Rs? So short answer would be yes. If owners are required to park their vehicles in the garage and it's in your CC&R saying that, yes, that is enforceable. A very common question that I get is, well, what if they have like a workbench in there and they, do all kinds of projects, in their garage, or they have a lot of storage in their garage and they don't have room to park their cars? That's their problem. They need to follow the CC&Rs, and just because they're using their garage as, a handyman station or a storage room doesn't give them a free pass to violate the other parking restrictions in the association's documents. Okay, question number 3. During an organizational meeting, should any business be conducted? Are members allowed to watch the organizational meeting? By organizational meeting, I mean the organizational meeting held after the annual meeting, where directors are elected, and after the annual meeting, the board will meet in the organizational meeting to elect officers. Okay, so this is kind of a gray area. Some associations' documents will, specify when the organizational meeting takes place, and it's very clear. Most don't. So here's just kind of what typically happens. Well, first of all, I would recommend that if you're having an organizational meeting after your annual meeting to elect directors and officers, or to elect officers or to appoint officers to your positions, the notice of that should be included with the notice of the annual meeting. So typically you're going to say at the annual meeting, we're going to be electing directors. Immediately following the annual meeting, we are going to have a short organizational meeting of the new board, and the new board will determine among themselves the officer positions. And I personally feel that the homeowners, if they want to stay and listen to that, they should be allowed to stay and listen. This is not an executive session topic. What typically happens, so in my experiences, you have the annual meeting. There's kind of a lot of people are there. There's some commotion because the annual meeting ends, and then the board says, "Okay, everybody, come over here and let's decide quickly who's going to be the officers for next year." And it's not real formal. It's, basically they just decide among themselves, and, the homeowners aren't really sitting there listening in. And so if you want your association to be more formal, ask them to, say at the end of the annual meeting, we're going to briefly adjourn for a few minutes to regroup, and then we're going to go right into our first board meeting after the annual meeting to, appoint officers for our community. And you're welcome to stay and listen, but you're also welcome to go home if you're ready to go home after the annual meeting. And should any other business be conducted? Well, if you are planning to conduct any other business, so the typical business would be the appointment of officers. If you're going to talk about anything else, the notice of the meeting should specify what specifically you're going to be discussing at that organizational meeting, in addition to appointing the directors. Okay, question number 4. One of our HOA residents passed away and her children put the home up for sale. The property has not been sold yet, but is presently in arrears for its monthly assessments. Does the management company or the HOA begin the process of collecting the amount due at the time of, or should we wait until the time of sale? That's a tough question. I guess one thing that I would look at is I would evaluate, does the owner own the property free and clear? So, or is there a deed of trust or mortgage on there? And what is that debt, ratio to the value of the property? If the owner owns it free and clear and the property is priced to sell, I probably would just lien the property to ensure that the lien is picked up by the title company when the property enters escrow, and maybe wait for 3 months and not do anything. But if the property is not priced to sell, like it's overpriced, then you may want to consider foreclosing on the estate of the decedent. It really is just going to depend on, why aren't they paying it? If it's a money thing, can you communicate with them and say, okay, you recognize that assessments haven't been paid here for 12 months, and, this is going to need to be paid at the time of the close of escrow. And, just open up the lines of communication with the family if you can. Obviously, if they've got it priced way too high and you're at the foreclosure threshold and they're not being reasonable, then you may have to consider doing a foreclosure proceeding. It just really kind of depends on a number of different variables. But you should be able to collect that money at the time of the closing on the property. And that would be a really effective way to get the money. You should put the lien on there, though, to protect yourself. Okay, next question is number 5. Our complex is owner occupied. No rentals are permitted. A property in our complex was sold. We learned that the management company posted on HomeWise that rentals were allowed. A board member called the listing agent when the for sale sign went up and told her no rentals are allowed. The buyer planned on using the property as a rental. The management company says it was the buyer's responsibility to have read the CC&Rs. What are our options now? Okay, definitely it sounds like there was a mistake by the management company. I don't think that a posting on HomeWise, which I'm guessing is like maybe where the disclosure information about the association is posted, it doesn't override the CC&Rs. If the CC&Rs say no rentals, that is the deciding factor. Now, it's a possibility that the buyer may sue the association for detrimental reliance on what was posted on HomeWise. I hope not. This is a sticky situation. It was definitely a mistake. If the management company, I don't know what your management agreement says with the management company, but if you have an indemnification provision where the management makes a mistake like this, they may have to defend you in a lawsuit, pay for your defense costs in a lawsuit. If you're named as a defendant in a lawsuit by this buyer, this is a sticky situation. I do ultimately think the association wins, but it could be sticky and there may be a lawsuit. But I wouldn't budge. I would not allow this person to rent their property because the CC&Rs are controlling here. Okay, next question is from an owner. How do you deal with a board who will not follow your governing documents? Example, passing an amendment with a majority of a quorum, 30%, versus a majority of all homeowners entitled to vote at a meeting. Second example, the board was legally removed in person pursuant to our bylaws, and they won't step down, and the board president worked for the property management company, and they won't enforce the removal. Okay, a couple things are important. First of all, in Arizona, we have a very specific board removal provision in the Condominium Act and the Planned Communities Act. So you want to make sure that if this is an Arizona association, that you are following what Arizona law says on removal of directors and not what bylaws say, because that's going to be controlling what Arizona law says. So just generally speaking, if you have a board that's not following governing documents, document in writing, so that there's a paper trail what they're doing wrong and ask them to change it. Consider running for your board. Consider moving, right? Consider suing your association. Consider going to the Arizona Department of Real Estate to file a petition against your board and having an administrative law judge look at the problems and rule in favor of the homeowner against the association. These are all different options that you have. Question number 7. If an owner uses a property management company to oversee their rental, do we still communicate with the owner and not the property management company for violations? This is a good question. Thank you for asking that. Okay, so if the owner puts in writing that we're supposed to be communicating with the property management company, of course, then we by law have to communicate with the property management company. It doesn't mean, however, that we can't do a CC to the owner. And why is this important? It's important because sometimes the management company isn't doing their job. And the owner doesn't even know it because the owner's delegated everything to the management company to handle. And so if the owner says, I want the management company to, be our primary contact for the HOA or condo, that's fine. But I also would still continue to CC the owner on any violations or any delinquencies pertaining to the association. Question number 8. We have a homeowner that needs to rent their home due to his wife being diagnosed with a disease or she can no longer walk up the stairs. Rentals are allowed prior to 2006 for 6 months. They purchased in 2018, therefore they're not allowed to rent. Under the CC&Rs, it says that the board may make exceptions under certain medical conditions, death, and financial reasons. This is definitely a medical condition. However, the majority of the board voted to not allow them to rent. Any suggestions for the owner to allow them to rent? Would the Americans with Disabilities Act apply in this case? Okay, so this is a tough question. So I guess suggestions for the owner is, selling the property, something that you may want to do because it's obviously not going to work with somebody who cannot walk up the stairs anymore as an owner. That's an option. Another option would be, I do not think the ADA applies in this case. The ADA is only going to apply, Americans with Disabilities Act is only going to apply if this is a place of public accommodation or if your association has a place of public accommodation. And I didn't know facts that support that. And honestly, that's pretty rare for associations. What might apply is the Fair Housing Act. And basically, you could say that this person has a disability as defined under the Fair Housing Act, a handicap, and ask for a reasonable accommodation under the Fair Housing Act to rent the property. The problem here is that there's another viable alternative, and that would be to sell it. And so that's kind of I'm not sure you win on that, but you might be able to argue that. And also, since the board can make exceptions, they have a backdoor on this. Of course, if they want to, they can allow an exception. Maybe you could negotiate a deal with the board where they give an exception for 1 year, and then at the end of the 1 year, you agree to sell the property. Maybe look for some creative solutions on that. Okay, question number 9. We have an owner that works in a restaurant kitchen, and when coming and going from the elevator to his door, he tracks whatever is on his shoes from the kitchen, such as grease, and it leaves dark streaks. It is obvious that he is the culprit, but refuses to take any remedial action to mitigate the damage to the common area. What can the HOA do to enforce rules to not damage common property? Okay, so you're going to have to prove that this, in fact, is the owner that's causing damage. Most CC&Rs, and prove it, meaning that you're going to have to have evidence, direct evidence that he's doing this. You're going to have to catch this person, obviously have a witness seeing that they're the ones that are causing the damage to the carpeting. In terms of your CC&Rs, typically there's a provision in there that allows you to charge the owner for any costs that are due to their damaging the common areas. So check your documents to see if you have that in there. And then you may want to get your attorney involved because it sounds like this owner is going to be difficult and is not going to accept responsibility for it, but fines and cleaning up the carpeting and charging them for the cost of cleaning up the carpeting are definitely an option. Okay, next question, number 10. If an owner won't pay a fine, can it be turned over to a collection agency? Yes, but remember what we talked about with fines, you really have to have the judgment, having the judge order that the fine needs to be paid to the association by the owner in order for it to be legally collectible. So I don't know if you have that judgment again yet. If so, then the collection agency certainly has the right to collect on it. If you don't have the judgment yet, the collection agency may be leery of sending a demand letter on that without the judgment. Question number 11. We have a resident that we have been dealing with for 4 years, and the legal fees have added up to over $20,000. We've already excused the fines that did not cost the HOA money. The owner took us to court. A judge known not to favor HOAs heard the case and ruled against us to the tune of $14,000. These are hard expenses that the board will now have to pay out of the budget. When should an HOA just give up and not escalate or pursue a resident? These are tough questions. Okay, so you had, a resident that I don't know if it was unpaid assessments or violations or what you were pursuing this resident for in court. But you had over $20,000 in legal fees. It sounds like, this has been ongoing for a long time. One thing that I noted is that you already excused the fines. In a case like this, you may not want to excuse the fines because the fines money could have been a way for you to recover some of those attorney's fees that were lowered. Another thought that comes to mind is, there are times where judges, don't rule in favor of associations, or maybe the judge feels that it's too much of a burden for the owner to pay the large amount of attorney's fees, or maybe the owner is repentant and, the judge may be less likely to make them pay the full amount of the attorney's fees too. Litigation is unpredictable at times. And so, 90% of the time we get 100% of the fees that we ask for, attorney's fees and costs, but there are some times where we get a ruling from a court that we don't understand why they, lowered it. So it does happen. Recognize though that when you pursue an owner for a violation, you may not have this owner, continue to violate the documents going forward. So there might be a benefit that since you filed the lawsuit, you're going to get compliance from this owner going forward. And unfortunately, sometimes there are expenses. These are business expenses that your board has, and sometimes you do have to just write them off. Maybe in the future, if you're going to have to go to that same court, you may want to be mindful of, okay, that judge likes to lower the attorney's fees, so we may not want to take cases to that court. We may want to go to Superior Court or a different court so that we, don't get in front of that judge. And talk about it with your attorney, because your attorney should have some good advice on, why the fees were reduced and what would be a good strategy going forward if you have another owner in a similar situation. Okay, question number 12. If an owner did not allow a vendor to repair outside of condo and HOA incurred $500 for the delay from the vendor, which owner was advised, can this amount be allowed to be passed on to the homeowner? I've seen this happen before where like an owner doesn't want painting done or something. I mean, I don't know if you advise the owner, was there an agreement that the owner agreed that, okay, fine, I'll pay that $500. If they did agree to it, that would be better. This is a tough call because in order to collect money from somebody, we have to have some sort of an agreement. Is it in the contract or was there a verbal agreement? So without knowing more, it may cost you more money to, try to fight about this with the owner. I don't know. You'd have to just see. You could try to add it to their account and see what happens first. And then if they really put up a stink, then maybe talk with your legal counsel in terms of what your legal rights are. Okay, how to convince the board of the importance of signing a code of conduct. I have a great cheat sheet on this, and you're welcome to take a look at that. It's a good idea. I usually don't bring out the code of conduct unless the association has a very high level of dysfunction. So it's not really something that I, hand out as a matter of course to every association. But remember that if you are having problems with board members, not living up to their responsibilities to the corporation, having a code of conduct and introducing it to your board is a great idea. And really, you just need a majority of the board to approve it, and then it applies to everybody on the board. And it's just a good reminder of the responsibilities you have serving on the board. And our cheat sheet that we have on this has some great information, and I hope you'll take a look at it. Okay, the next question. Do we need to have the statutory language in all violation notices that they may file an appeal with the real estate division, or can the appeal just be with the board? It's my opinion, to be safe, have that language in all of your violation notices to comply with the statute. Okay, next question, number 15. And it looks like we have 23 total questions. So we're moving right along here. Next question is from an owner. I recently attended a class on the grievance process with the ADRE. It is my understanding that the ADRE has no power to enforce a judgment rendered by an administrative law judge. What do I do with a judgment rendered in my favor? Present it to the board? Yes. What you should do is, if you went to the ADRE and you prevailed against the association, they should have received a copy of it. If the association, they should have received a copy, but you could also send a copy of it to the board. And if they, don't do what they're supposed to do under the judgment, you may be able to go back to the ADRE and have a hearing to find out, why, and, just try to get back in front of the judge. Or you may want to contact the board and say that you want to have a meeting with them. You may want to get your own attorney to send a letter making sure that they comply with the ADRE ruling. Honestly, one of the problems with the Arizona Department of Real Estate is that those rulings don't have a lot of teeth. But if one of my clients received an adverse ruling from the ADRE and it ordered, basically, or made a statement that the association did something wrong, I would advise them that they correct their actions. Because my experience with the administrative law judges with the ADRE has been very positive. They are very intelligent and well-versed on Arizona law pertaining to HOAs and condos. And of course, the association had the right to appeal it if they didn't like the decision. And they need to abide by what that judge says, in my opinion. Question 16. CC&Rs prohibit RVs visible from neighboring property and common areas. Owner moved in and has a Class B camper van that they park in the driveway. By FEMA definition of an RV, it is an RV. It looks like a large, long, and tall van. To be fair, should the board bring this to their attention, letting them know it needs to be garaged to remain on site? If it's classified as an RV, yes, I think that is the appropriate action for the board to contact them and ask them either to not park it in an area that is visible from neighboring property or from common areas, or to park it in the garage. Next question, number 16. CC&Rs prohibit an RV visible from neighboring property. Oops, let's see, I already did that one. Question 17. Do Airbnb guests come under the $25 tenant fee? So yes, they do. So short-term rental guests, longer-term leases, any lease, whether it's short-term or long-term, have that $25 tenant fee, and it needs to be paid for each new tenancy, whether it's short or long. Okay, question 18. Our HOA is in the city limits. We were told by the city that the HOA cannot have rules in the CC&Rs as it is a public street. Is this correct? I don't know enough about your association to weigh in on this. So I don't know when your association was created, because there is a law that talks about, if your association was created after a certain date, that if the streets are dedicated to the public, the association cannot have parking restrictions on those streets that are dedicated to the public. I don't know what your CC&Rs say about on-street parking, so it's really difficult for me to answer this question. What I would do is I would bring all that information to your association's legal counsel and talk through, when your association's CC&Rs are recorded and whether or not that law applies to you or does not apply to you. Question number 19. We have a homeowner that put up a chain link fence on part of their property. Our CC&Rs state that any fences or wall must be done with masonry. There was a bush shielding the fence, but just recently came down and was noticed. What can the HOA do about this? I don't know how long the chain link fence has been on their property. So if that violation has existed, even though it may have been covered up by a bush previously, that's an important fact that I would need to know. Like, if that chain link fence has been there for more than 3 years, it may be really difficult to enforce this. So what I would recommend here is contact the owner and find out what's going on. When did they put up the chain link fence? Why was the bush removed recently? If it's been there for more than 3 years, meaning the chain link fence, maybe you can try to work something out with the owner that they install a new bush so that we don't see it. But they may be allowed to have it because it's been there for such a long time period without any action taken by the board, even though the bush may have been, shielding it and we couldn't see it. Next question, is the current Arizona homestead exemption $250,000? What are the exceptions? Okay, great. My office is amazing. They already put the statute right here on my screen for me. So ARS 33-1101 talks about the homestead exemption. It was increased maybe last year or the year before by our legislature, and it is $250,000. And it says, basically the homestead exemption, allows them to protect, it says any person 18 years of age or older, married or single, who resides within the state may hold as a homestead exempt from execution and forced sale, not exceeding $250,000 in value. And that would be for their, they have to reside in the property. So it could be in any planned community where they reside in that property or any condo where that person resides. So if it's a rental property, they would not be able to claim the homestead exemption. Now remember though, that the homestead exemption, there's a specific exception that the HOA foreclosure lien, is exempt from, that particular provision. So if we're foreclosing on an owner in a planned community or condominium, they cannot claim that homestead exemption. Okay, question number 21. We have a flipper, meaning like a house flipper, I'm guessing, who has a house closing on Thursday. The family moving in has 3 residents under the 45-year-old rule. In fact, 2 are small children. The flipper said that our community would allow the family. We are a 55 plus community. The title company is going ahead with the closing. What are our options? Okay, well, first of all, I would make sure that you notify the realtor, the seller, and the buyer in writing that this is a 55 and over community, and give them the sections in the CC&Rs. And I would do this immediately in writing. Give them the sections in the CC&Rs that are going to apply to the situation, and let them know that if they move in and violate these sections, that the association will take legal action against them. We're providing them notice of these sections at this time, and that's the best you can do. So the title company, the realtors, the buyer, and the seller, all of that information about the CC&Rs and that your 55 and over community should be provided to all those parties. If they proceed forward and the underage residents are residing in the community, you just need to turn it over to your legal counsel and have them pursue them for this violation. Question number 22. Our CC&Rs say we are not allowed to run a business out of our home. One home was turned into a group home or a halfway house. They have a business license in place to operate. Can the halfway house be forced to close? So under the Fair Housing Act, group homes, for the disabled, for the elderly, and for certain classes of people, and I don't know if a halfway house is going to qualify, but sometimes recovering addicts, that is something that is covered under the Fair Housing Act. I need to know more about what the group home is for, but it's very likely that that is allowable under the Fair Housing Act, and the association will have to allow this group home to, operate in your community. What you want to do is get more information from the city regarding the business license that they have, and then take that information to your attorney and talk about what your legal options are. Okay, our last question for today. Are board member emails between each other public record? Or I'm guessing like association records. And so it depends. Are two board members communicating? Is that considered a book and record of the association? If it's less than a quorum, probably not. So if two is less than a quorum of board members, it's probably not something that is going to be a record of the association. If really, again, board members shouldn't be communicating by email though, because we don't want to violate, the open meeting law. All decisions of the board should be done at an open board meeting, not by email unless there's some sort of emergency that dictates, a response by email. So the question is, though, are board members' emails between each other? So I don't know, maybe if it's more than a quorum or more, yes, I do feel that would be considered a book and record of the association. And again, I'm going to caution you about violating the open meeting law. Okay, we had one late entry question, and my superstar office got it in for us to take a look at. So this will be the last question. If a resident has late dues fees, but when they pay HOA dues, they don't include late fees. Instead, they write in the memo part of the check that the extra amount is for 1 or 2 months of advance dues owed. Can we pay off this resident's late fees from the HOA dues paid in? If they have a memo on the check dictating or directing how the money needs to be paid, you have to follow that. And so you cannot put that towards the late fees. However, you can pursue the owner for the late fees. So you may want to, potentially file a lien if there are a lot of late fees that have been accumulating, or have the matter go to the attorney. But the way that they're doing the check with the memo and specifying how the money should be applied, you have to apply it that way, unfortunately. That person's a savvy person that you're dealing with. So you may want to get your attorney involved, because it's clear to me that they know what they're doing. They're trying to get around paying the late fees. Make sure that you're checking out our Facebook page for Mulcahy Law Firm and liking it, and subscribing to our YouTube channel, because we're putting all kinds of great content and free information on there for board members, managers, and homeowners. We've reached a total combined views on our YouTube channel of over 63,000 views since April of 2020. That is beyond my wildest dreams in terms of the popularity of these classes and of the videos that people are watching after the classes. So thank you so much for supporting our firm and supporting the different neighborhood services departments for all of these different cities, towns, and municipalities that we're working with to provide this free education to you. We also have some great free resources for board members. We've shown you a couple of cheat sheets today during this presentation. Our website at mulcahylawfirm.com has all of our cheat sheets, all 60 of them, all of our past videos that we've taught over the past 2 years as well. So I really encourage you, if you're looking for information or looking for answers to questions about how to run your association, is my board doing things correctly, go to our webpage at mulcahylawfirm.com and look at all of our free resources on there for you. We get a lot of positive feedback from owners and board members and managers about how easy the website is to navigate and how thankful they are to have a resource to answer questions. So we encourage you to take a look at our website. We also started a podcast, and you can find information on that on our website as well, or contact our firm. Also, don't forget, we have our virtual First Friday free call-in on Friday, November 4th at 9 a.m. We always have a great turnout of people asking questions, and we usually get through 50 or 60 questions each First Friday. So hope if you have any additional questions each month, make sure you're tuning in for that on Zoom and Facebook Live. Additional details can be found on that on our website, and you can continue to submit questions right up until the morning of November 4th. Thanks again for being here today. It's our pleasure to partner with the neighborhood services departments from many different cities around the valley to create this free education for board members, homeowners, and managers. I'd like to give a special shout out and thank you to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for being our partners in this virtual HOA Condo Academy. We hope to continue to do programming for you for the rest of 2022, of course, and also all through 2023, so that we can continue to provide you with the resources that you need to make your communities better. So thanks everybody for being with us here today. Take care, everybody. Have a happy Halloween, and I look forward to seeing you in November.